The Honorable Bombay High Court has given a historic and landmark judgment in order to prevent the unnecessary media trial. Because nowadays, in several platforms like television, WhatsApp, Facebook, Twitter, etc., we are seeing that the cases are being discussed in a so brazen manner that the right of the accused, even before filing of the charge sheet or before completion of the trial, gets highly badly affected. Not only the accused, but also the victim's right are affected, and the actual trial process which goes on before the court are in jeopardy. Let's take a look at the judgment given by the Honorable Bombay High Court.
In the High Court of Judicature Bombay Civil Appellate Jurisdiction Public Interest Litigation, Street 92,252 of 2020 with Interim Application 95,156 of 2020. Mr. Naleshni Valeka and others versus Union of India and others.
Having given our anxious consideration to all aspects of the matter, we are inclined to the opinion that the press media ought to avoid or regulate certain reports or discussions or debates or interviews in respect of, and or touching upon, any ongoing inquiry or investigation into a criminal offense, and that only those items are presented for reading or viewing, and otherwise perceiving through the senses, which are merely informative,
but in public interest, instead of what, according to the media, the public is interested in. No report or discussion or debate or interview should be presented by the press or media, which could harm the interests of the accused being investigated,
or witness in the case, or any such person who may be relevant for any investigation, with a view to satiate the thirst of stealing the march over competitors in the field of reporting. Accordingly, we direct the press or media to exercise restraint and refrain from printing or displaying any news item and or initiating any discussion or debate or interview of the nature as indicated hereunder.
In relation to death by suicide, depicting the deceased as one having a weak character or intruding in any manner on the privacy of the deceased,
that causes prejudice to an ongoing inquiry or investigation by firstly referring to the character of the accused or victim and creating an atmosphere of prejudice for both, secondly, holding interviews with the victim, the witnesses and or any of their family members, and displaying it on screen, thirdly analyzing versions of witnesses whose evidence could be vital at the stage of trial, fourthly, publishing a confession allegedly made to a police officer by an accused, and trying to make the public believe that the same is a piece of evidence which is admissible before a court, and there is no reason for the court not to act upon it without letting the public know the nitty-gritty of the Evidence Act, 1872.
Fifthly, printing photographs of an accused and thereby facilitating his identification. Sixthly, criticizing the investigative agency based on half-baked information without proper research. Seventhly, pronouncing on the merits of the case, including prejudging the guilt or innocence qua an accused or an individual not yet wanted in a case, as the case may be.
Eighthly, recreating or reconstructing a crime scene and depicting how the accused committed the crime. Ninthly, predicting the pre-post or future course of action, including steps that ought to be taken in a particular direction to complete the investigation. And tenthly, leaking sensitive and confidential information from materials collected by the investigating agency.
Acting in any manner so as to violate the provisions of the Program Code as prescribed under Section 5 of the CTVN Act, read with Rule 6 of the CTVN Rules, and thereby inviting contempt of court, and indulging in character assassination of any individual, and thereby mar his reputation.
While we have ourselves suggested measures that need to be followed so as to enforce the right to life of individuals accused of criminal offenses under investigation, as well as laid down guidelines for media reporting on criminal investigation at the pre-charge sheet stage, the latter is with the obvious intent of marking the Lakesman Rekha within which the media must operate to avoid contempt of court.
If this judgment is properly complied with by the medias, then certainly the trial which goes on before the court will be properly concluded, and the basic criminal principle that a person is innocent until proven guilty will be respected. That's all. Thank you.